All right, top of the hour, let's begin with a breaking update. What we are learning from the Supreme Court, the Shahi Masjid Committee of Mathura, the Masjid side in Krishna Janmabhoomi case, has now filed an application in the Supreme Court accusing the centre of deliberately not filing a counter affidavit to please challenging the validity of the Places of Worship Act, so that the whole issue, the adjudication of the constitutionality, hangs in limbo. Here is the Mosque Committee or the Masjid side, which has sought directions from the Supreme Court to close the right of the central government to respond to the petition, so that can the case then proceed further, can move on. Now let's get in a word from Harish, our legal editor joining us live. Good morning, Harish. Now this is the Masjid Mathura panel accusing the centre of delaying the response on 1991 worship law. What are they saying as to they moving the Supreme Court seeking directions to remove the centre's right to reply?
Yes, Amita, for the benefit of the viewers, let me say that it's a fact that the centre has delayed the filing of the response. Remember, the first notice was issued to the centre way back in March 21, 2021. So almost for 4 years and 10 months, the centre has not responded to the pleas challenging the Place of Worship Act validity. And also the last deadline, request was made to the centre on December 12th by the Chief Justice Sanjeev Khanna bench, which had given 4 weeks time to the centre to file its reply, but that has also expired. No, the centre has not filed its reply. Now the Shahi Eidgah Masjid Committee, Management Committee, has filed an application in the Supreme Court telling the Supreme Court that let us go ahead with the hearing, just shut out, close the right of the centre to file its response, and because this is just a delay tactics on the part of the centre, it just wants to prolong this hearing and also obstruct the Muslim parties from filing their objection to the petitions challenging the validity of the Place of Worship Act. Therefore, let us go ahead with the hearing, just close the rights of the centre without hearing the centre, let the hearing happen, and let the matter be between the Hindu petitioners who have challenged the validity of the Place of Worship Act and also the opposition parties and the Masjid side. Let the Supreme Court not hear the centre. And this comes at a time, Amita, when the Supreme Court has extended the deadline for the centre several times, saying that view of the centre must be known for proper adjudication of this very contentious issue. Despite that, the Shahi Eidgah Committee of Mathura, which is the Masjid side in the Krishna Janmabhoomi matter, is urging the Supreme Court to shut out the centre from the whole hearing and asking it, don't give any further time.
Mr. Jain is with us on the phone line. Let's get in a word from Mr. Jain. What do you believe, Mr. Jain, on part of the Masjid side saying that the centre did not file a response for almost 5 years, and the court, however, directing the centre to file a response, but now the deadline has expired and the central government has not filed a counter yet? What's taking so long?
This application has been filed only for cheap popularity and unnecessary, bringing such things which are not required to be placed before the public. Unnecessary matter is being politicized, and this issue unnecessarily being dragged. It is the part of the central government to file the affidavit or not affidavit, how they are concerned. We are the petitioners, how they are concerned. It is immaterial, and they have no right to say that particular party must file an affidavit. It is for the court and the government. We are not concerned with the parties, are not concerned. Either the petitioner or the opposing party. It is between the court and the government.
But Mr. Jain, can the Masjid side seek directions from the Supreme Court to close the right of the central government to respond in the petition so that the case can proceed?
It is not a civil court. It is like Order 8 Rule 1. You close the right of filing a petition statement. It is Supreme Court. Supreme Court decide the case under Article 32, and the court has ample power to grant time. And no party can say they close the right. They will not be there. That is an incorrect approach. And I again repeat that this application has been filed unnecessarily, only for publicity.
Because they have been saying that the centre did not file response, and the directions that came in from the Supreme Court, that was for about 4 weeks, but the deadline has expired and the centre still has not filed a counter. Exactly what could be the next step from here on as far as when can the centre respond to the petitions?
It is for the centre to file affidavit and not to file affidavit. No party can compel any party to file their affidavit. This is not a direction, it is the sweet will of the party either to file or not to file. They may orally argue, they may oppose or support the petition orally, or they may convey their viewpoint before the court in their own manner. Filing of affidavit is not necessary. I think for the government to decide, and it is between the court and the government. No party can come in between.
All right, so you're saying that it is now the centre's prerogative to respond as far as when it comes to the time is now concerned, not the Masjid side who will decide and will seek the directions coming in from the Supreme Court. Thank you very much, Mr. Jain.